Major breaking news as President Donald J. Trump has just won yet again at the Supreme Court, shutting down a nutty anti-Trump decision by the U.S. Court of Appeals for the First Circuit, in addition to a nutty anti-Trump decision by John McConnell, a federal district court judge, also known as a political partisan wearing a black robe. Let's break down this big win for Donald Trump over a rogue judiciary when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, another huge win for President Donald J. Trump at the United States Supreme Court. In this case involving an attempt by a federal trial judge, a Barack Obama judge by the name of John McConnell out of Rhode Island, who, as an Article 3 district court judge, has taken it upon himself to essentially control the federal government, it seems. To tell Congress to give the president money that he doesn't got, that doesn't exist, because there's a government shutdown. And then for Donald Trump and his administration to take that non-existent money and spend it by fully funding the program of SNAP benefits, which is basically food stamp and welfare. That's right. As you may recall in this case, there was a lawsuit brought in light of the government shutdown and the risk that the government was not going to be able to pay food stamp welfare, known as the SNAP program, to millions of people. How many are illegal aliens? I'll let you be the guess. I'll let you guess at that number. But millions of people that use this welfare handout to feed themselves, apparently, supposedly. And John McConnell, an Obama appointee to the federal bench of the District of Rhode Island, surprise, surprise, a group of plaintiffs sued the Trump administration, not in Texas, not in Louisiana, not in Florida, but in Rhode Island. Why? Because they are within the worst court of appeals in America, if you respect the Constitution and you respect America, and that is the U.S. Court of Appeals for the First Circuit. Now, for those of you who are familiar with the Four Boxes Diner and the Second Amendment and how to understand all that, you know, and have known for years now, that the literally worst circuit in America for America and Americans, in my view, is the U.S. Court of Appeals for the First Circuit out of Boston. There's literally no combination of three judges that will respect the Constitution as I see it. So sure enough, because Rhode Island is in the jurisdiction of the First Circuit Court of Appeals out of Boston, Massachusetts, the plaintiffs wisely sued in Rhode Island. And Judge John McConnell entered an order telling President Trump to spend all these millions of dollars on SNAP benefits, even though the government was shut down and there was no money to spend. So you may recall we covered this, that there was an immediate appeal all the way up to the First Circuit Court of Appeals in Boston, but they sat on their hands and did not act quickly. And then John Sauer, the Solicitor General of the United States for Donald J. Trump, sought an immediate administrative stay, which means a pause or a freeze, of Judge John McConnell's order telling Donald Trump to pay a bunch of money that he didn't have. And the U.S. Supreme Court, specifically Justice Ketanji Brown Jackson, literally stayed, meaning stopped, this order from taking effect. That's right. That's how crazy the order originally was, that Justice Brown Jackson literally shut down Judge John McConnell's order to pay all this money that doesn't exist to welfare beneficiaries. Well, what just happened? What was the purpose of that administrative stay initially? The purpose of that stay was to allow the U.S. Court of Appeals for the First Circuit out of Boston to have an opportunity to weigh in specifically on the merits of whether or not Donald Trump and the Congress have this obligation to pay all this money to welfare beneficiaries under the SNAP program. That was the purpose of the initial stay last week. Well, the U.S. Court of Appeals for the First Circuit, surprise, surprise, with a couple Biden appointees and an Obama appointee. Remember, worst court in America, folks, First Circuit Court of Appeals, Boston. Even though they have like a super uber wealthy courthouse. If you want us to do something fun, Google photographs of the U.S. courthouse in Boston, Massachusetts, where these judges hang out, and check that out. Oh yeah, that's fancier than where most of us live, I can assure you. Check it out. Think about that. For public, government servants, government employees get to work in that building that's worth hundreds of millions of dollars. Well, anyway, I digress. With the courthouse, where the U.S. Court of Appeals for the First Circuit sits. Nevertheless, the U.S. Court of Appeals for the First Circuit with Obama and a couple Biden judges did exactly what you would expect, which is they said, of course, we as Article 3 judges under the U.S. Constitution have every right and all the legal authority on the planet to dictate that the President of the United States and Article 2 head of the executive branch has to pay out all this money that doesn't exist, even though Congress, the Article 1 legislative branch, is shut down and shut down the government. The Schumer shutdown. That's right. You have an Article 3 court, as I see it, ordering the Article 2 president to pay a bunch of money that the Article 1 Congress never allocated because they shut the government down. These courts, shall we say, the word hubris should be in every single sentence describing some of these courts in America. Well, needless to say, the Trump administration immediately sought an immediate appeal to the Supreme Court. And I'm happy to report that the U.S. Supreme Court has just ruled in favor of President Trump that the order of Judge John McConnell, the district court judge in Rhode Island, and the order affirming Judge John McConnell's order, that order affirming Judge McConnell by the U.S. Court of Appeals for the First Circuit in Boston, those orders telling President Trump to spend money he doesn't have that Congress didn't allocate to this program, those orders have been frozen or stayed by the U.S. Supreme Court. And what's interesting, that now that the First Circuit has ruled, guess who dissented or articulated the view that she would not have signed off on this administrative stay? And that is, believe it or not, Justice Ketanji Brown Jackson. Talk about inconsistent. Anyway, here's what the Supreme Court order said. Ruling in favor of President Trump, extending this administrative stay likely through the end of the week, essentially to allow the government to reopen, at which point this case will become moot. Here's what the Supreme Court wrote. In the case of Rollins versus the Rhode Island Council of Churches, quote, the application for stay presented to Justice Brown Jackson is referred to the Supreme Court. The administrative stay entered on November 7, 2025 is hereby extended until midnight, basically, on November 13, 2025. Justice Jackson would deny the request for extension of the administrative stay and would deny the application by the president. Well, this is the obvious right answer, because it appears imminent that the federal government is going to reopen because Chuck Schumer could not keep his Democrats in line, and a whole bunch of defectors from the Democratic Party peeled off to vote with the Republicans to reopen the federal government. It appears that that's going to happen, and the money will start flowing again in a matter of a day or two, which means this entire litigation forcing the President of the United States to spend money he doesn't have to pay money to these welfare recipients, these food stamp recipients, is going to start flowing again because Congress is going to refund all this, and this money will now be available, and the president's executive branch can then send the money out. So this delay is a huge win, and I suspect the Supreme Court would rule 100% for Donald Trump, but now they can essentially buy President Trump time. A few days here, the money will start flowing, and this case will become a moot point because the whole purpose of this lawsuit was to force Donald Trump to spend money he didn't have on these welfare recipients. And guess what? That is not going to be an issue now because the money will be available and will be spent, thus mooting out this case. Now, just to show you how, in my view, the U.S. Court of Appeals for the First Circuit out of Boston are really just partisan hacks, advancing the progressive cause, which is what these liberal judges do, right? And this is the key thing to understand, folks, that while conservative judges known as originalists are trying to figure out the meaning of the law and apply to the facts presented to them in a particular case, the left-wing judges have a much easier job. They know their job is to simply rubber stamp whatever side is advancing the progressive agenda. They're outcome-oriented because these left-wing judges are not left-wing judges, in my view. These left-wing progressive judges are really just partisan political actors that happen to wear robes and have the word "the honorable" in front of their names by virtue of tradition. But the reality is their understanding of the law, their understanding of the Constitution, their understanding of the role of Article 3 judges is quite simple, which is to do whatever it takes to advance the left-wing agenda. And when, quote-unquote, democracy does not vote in favor of the left-wing progressive agenda, then it is up to the courts to step in and to advance the left-wing agenda to correct the mistakes made by democracy. That's right. And that's why when democracy votes against gay marriage, it's up to the courts to find that there's a constitutional right to gay marriage. And likewise, when we, the people, democracy, do not support the right to an abortion, the purported right to an abortion, it is up to they, the unelected judges, to step up and find somehow in the constitutional text a right to abort one's child. That's how the game historically got played. And the fact is that the U.S. Supreme Court are now majority originalists, meaning they're just trying to understand what is the law and apply it. This really angers the left wing in America. But the U.S. Court of Appeals of the First Circuit and Judge McConnell, in my view, are simply partisan hacks that wear black robes and go by the name judge. But the reality is they're just political actors advancing the cause of the left. Now, from their point of view, they think they're doing what judges are supposed to do, which again is correcting the mistakes of democracy when democracy does not go along with the left-wing agenda. And when the democracy doesn't go along with the left-wing agenda, whether it be on abortion or gay marriage or transgender issues, whatever it is, then it's up to they, the unelected judges, to help along the left-wing progressive cause, force that decision upon the people that voted against that stuff. That is the reality on the ground. Now, that is exactly what happened here, where Congress and the president could not agree on terms to open the government or keep the government running and to fund these food stamp programs. Nevertheless, these judges stepped in and said, we're going to do two things. We're going to force President Trump to spend money he can't spend because there is no money. And even if we can't do that, we're going to force President Trump to come across as orange man bad, orange man evil, because he's going to have to go to the Supreme Court and say, we cannot fund, or we should not be required to fund money and pay for this welfare and pay for these EBT cards. And that will be politically good because it will make orange man bad, because orange man is mean, because the orange man went to the Supreme Court and went to the courts arguing that these monies should not be paid. And if there's any doubt that this First Circuit Court of Appeals out of Boston are partisan actors, one only needs to read the beginning of their opinion, which is 29 pages ruling against President Trump, which is really just an appeal to authority and a bunch of crying about, the importance of this program, which is perfectly true that this program may very well be important. But the arguments they're making, which I'll read to you in 1 second, are really the kind of points and arguments one should be making to the legislative body, to the Congress, to Chuck Schumer to reopen the government and fund this stuff. Instead, these First Circuit Court of Appeals judges played the role of policymaker, and if you don't agree with me, check out what they said and tell me if this sounds like the kind of argument you hear in court cases or is the kind of argument you hear in the context of a fight over legislation and spending in Congress. Check it out here. 42 million people, 1 out of every 8 Americans, use monthly benefits from the Federal Supplemental Nutrition Assistance Program, SNAP, to buy food for themselves and their families. On October 24, 2025, a few weeks into the current government shutdown, the United States Department of Agriculture, which administers SNAP funding on behalf of the federal government, announced it would not provide any funds for November SNAP benefits. The plaintiffs in this case, nonprofits, local governments, a union, and a food retailer, sued to require USDA to provide full November benefits using the SNAP contingency funds Congress had appropriated for this very purpose, as well as for other funds available to USDA. That's the U.S. Department of Agriculture. It goes on to say that SNAP provides monthly benefits to around 1 in 8 Americans, including 14 million children and 8 million elderly individuals. Beneficiaries receive funds through the electronic debit card that they use to buy food at grocery stores and other food retailers. And of course, it goes on to say, for low-income Americans, SNAP is a vital bulwark against hunger and food insecurity. Access to food is, of course, a basic human need. Further, food security is a critical factor in health and well-being, the ability to stay in stable housing, and children's physical and educational development. Without SNAP, tens of millions would go hungry, the first among a cascade of other health and financial harms that would befall those forced to go without enough food, particularly in the months leading up to the winter. Well, that sounds like an argument to open up the government. Sounds like they should be writing that to Senator Chuck Schumer of New York and say, open up the government. But no, what do they do with all those facts and all those arguments? Do they go to the Democrats in the Senate and say, stop filibustering the closing of the government and open up the government and vote to open up the government? No. They make these political arguments attacking essentially President Trump for being orange man bad and a meanie. Because he refuses to spend money he doesn't have. Because the government is closed. Congress did not appropriate the money for this program. And this Article 3 judges somehow think that there's some other money allocated to children's programs and other programs that they can just order the president to take from other programs and spend it on this. Crazy stuff. Crazy stuff. I presume that these judges think that the beneficiaries of the SNAP programs are all Democratic voters. I'm sure that is something that went through their minds. Just a guess. My speculation, but I guess I'm probably right. But the good news is, folks, that the U.S. Supreme Court saw through all of this and they understand what's going on. And now they've entered an order that shuts down this ridiculous order by Judge John McConnell and this ridiculous order by the First Circuit affirming Judge McConnell. And the reality is that they prevented this from occurring. But it's all going to be a moot point because the government is reopening and the Supreme Court is not going to have to bring down the hammer and say the obvious, which is an Article 3 judge lacks the legal authority under the Constitution to tell the president to spend money that was never allocated by Article 1 Congress. And it's just absurd to think this is even possible. And again, the only reason why this is going on is because these judges in the Northeast are trying to set up Donald Trump to make him look politically bad. And I don't think it will work. But maybe anything's possible. I cannot tell you. But it doesn't seem to have worked that far. And of course, it's all a moot point anyway. All right, folks. So there you have it. Hope you enjoyed today's episode. Make sure you follow me on X at @4boxofdarn. Don't forget to subscribe to YouTube and to Rumble. And I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.